Good morning, good afternoon, depending on where you are joining us from. We are here today with the folks from Meyer Law, Trisha Meyer and Melody Ashby. Welcome.
Thanks for having us.
It's a pleasure. I am glad you're here. We'll talk about some contracts today and why they're so important for IT businesses.
Yes, exciting stuff. We'll try to keep it interesting.
That's awesome. That's awesome. Well, we've already been laughing a little bit before. Seems I had the name. I've been working with you all for God, what, 2 or 3 years now?
Yes.
I think you've written all my contracts and you haven't corrected me until just now on how to pronounce your last name.
It's okay. It's okay.
But for the audience, I had been saying Meyer Law, but it's actually Meyer Law. So I stand corrected. But well, so we'll get right into it. Well, actually, before we start talking about contracts, I wanted to find out. So, Trisha, you founded Meyer Law, and what is your background as an attorney, and where'd you get your tech skills from with the tech law? Because that's what Meyer Law does, right? Tech.
Exactly. Yeah, great question. So I started off my career at a software company in Denver, Colorado. Went to school for products liability and medical malpractice, totally shifted, got this job offer at a software company, took it, really enjoyed it. And the tech kind of started there. I continued on and worked at HSBC and Reliance Globalcom and Discover in their kind of tech divisions, working on tech contracts. And so when I started my firm, naturally, I focused on helping tech companies because that's really what I was knowledgeable about.
Awesome. So you had some previous experience in the tech industry or tech world.
Yes.
That's great.
And we are really passionate about helping businesses. We absolutely love it. And, started the firm almost 12 years ago now.
That's wonderful. So your firm is featured. Am I correct in saying it's in the 5,000? Is it you were featured in the?
We've been featured on the Law Firm 500 list, which is one of the fastest growing law firms in the U.S. for the 3rd year. We should hear pretty soon here if we made that list for the 4th year, which fingers crossed we have. But time will tell on that. So yeah, we've got a lot going on, really busy helping lots of companies.
That's awesome. Well, Ms. Melody, tell us about your experience.
So my experience was, after graduating law school, I kind of graduated during that bubble. And so it was quite difficult actually after I got out of school, figuring out what I even wanted to do, because I actually had no idea. I was in a situation where I could either go into litigation or I could go into corporate law helping businesses. And I chose the one that paid more.
So, I don't blame you.
And so I fell into corporate and helping small businesses and really focusing more on the corporate side of things, and did that for, about 4 years. And then I met Trisha and kind of switched over and have been with Meyer Law ever since. So going on, I think about 9 years now with Meyer Law.
Oh, that's great. Now, Meyer Law you have offices in 3 locations, if I'm not mistaken.
That's right. Chicago, Denver, and Los Angeles.
Okay, great. Well, I know you have completely helped me in both of my businesses here in IT Business Owners Group with contracts and sponsor contracts and website stuff. You've also helped us in our managed service provider business, where you've given us. I think you drafted up an MSA and an SOW for us, so we are very appreciative. We really like it. But well, let's get into contracts. So I guess the first thing I want to ask you is, this is a great entry. Why are contracts so important?
Because it's more costly to clean up the mess after the fact. I think that would be my one line answer there. For so many reasons, they're important to make sure that everybody's aligned and everybody's expectations are, everybody's on the same page, and making sure that you can hold somebody's feet to the fire if they're not delivering. And then just making sure that everyone's aligned on the nuances, surrounding the relationship, the duration of the relationship, all of that. And then the fundamentals of protecting confidential information and intellectual property, two of the most valuable assets of any business. So that was a lot there, but there's so many reasons why contracts are important.
Yes, and there's so many. What kind of advice would you have for the business owner, IT business owner, who is starting up? Because I used to be that IT business owner that doesn't have any contracts in place. They don't really know where to start. They know that they know that it's something that's necessary and needed, but they just don't know where to begin. What kind of advice would you give for someone like that?
I would say that get a consultation with an attorney. You don't know what you don't know. From our perspective, we help you fill in those blanks, learn about what it is exactly, essentially what it is that you're doing, how it is that you should be protecting yourself, especially early on. A contract is so key because without one, you're taking on, well, you could even have a contract taking on unlimited liability, but there's normally a section in a contract. It's all in caps. It's called the limitation of liability. If you don't have that language in your agreement, or if you don't have an agreement at all, you're taking on unlimited liability. And when you're first starting out, one way to kind of limit your liability is to have that provision in your agreement. A lot of times maybe you don't have insurance in place yet to protect in the event of something happening from a negligence standpoint or just errors and omissions in general. And so the way to do that is to set up an agreement. And it doesn't have to be, this crazy, 30-page agreement either, but have a consultation with an attorney to figure out what it is that you're providing, and at least the basics of how to protect yourself, making sure that you're getting payment from your customers, making sure that you have recourse should something go wrong. Those are, some simple terms that you could put together, even just to cover off the specific services that you might be offering.
Well, that actually, you said specific terms. So that intros to another question I have for you. How important is the verbiage and wording of legal agreements and documents?
Yeah, so I would say very important because
Sure.
you can have an agreement that's clear as mud. And, I've read some pretty crappy agreements where I'm like, I don't even understand it. And, I'm an attorney who reads contracts all day. And so having, a clear, so I will say that there is language that has already been litigated. So oftentimes you'll see attorneys using similar language within agreements because they know the enforceability of that language. We've seen situations where we've had clients, for example, draft their own agreements. And when we receive them, we're like, this really isn't worth the piece of paper it's even written on because it's just not clear. So, I can't stress enough how, you really need to set forth language that is clear. In some instances, the language should be conspicuous. So all of those things should be taken into consideration when you're thinking about your business and how you want to protect it.
And then I'll also add that a lot of the provisions of a contract hang together. And so, for a lot of those people that kind of DIY, do it themselves, kind of put something together, they don't realize the impact of including various sections together or the contradictions that are potentially created. So, making sure that the language is clear and making sure that all the sections fit together is really, really important. And then I'll also say, looking at the structure, the terms and the protections and the remedies and all that stuff aside, looking at the structure and how to best structure your contracts for the various relationships is a really important exercise to create efficiencies from an operational standpoint. And, to make sure, like from a client standpoint, you're getting money in the door that much more quickly by using an efficient mechanism to get contracts signed.
Well, one thing that IT business owners are notorious for, I was prior to meeting your firm. How bad is it to take another business's or another IT provider's contract and use it as your own? Just change the
Well,
name.
yeah, I mean, we obviously don't recommend it because it's plagiarizing, but you don't know where the contract came from. You don't know the nuances of their business. Every business is kind of run differently, and everybody has a different risk tolerance, and all of those things should be looked at and assessed when drafting a contract. And I think that sometimes companies will pull terms, let's say, from a company that looks similar to theirs, but they don't realize that they don't have the protections that they should have, considering the relationships that they're entering into. And they're out there thinking that they're protected. And then it's not only until, shit hits the fan that they realize that they should have done it in a different manner, drafted things in a different way, or maybe tightened it up a little bit. So if we always say, if you're going to pull a contract from somebody else, your best friend, somewhere online, wherever, at least have a lawyer review it to make sure that it's in line with your business, your expectations, your risk tolerance.
Yeah, because businesses are not one size fits all.
Right.
So then, like you said, I know when you helped me and first started with my contracts, I kind of cringe at them a little bit. I'm like, oh my gosh, because they're long, but those Word documents, you ask all the questions, and they're hard questions, but they get you thinking. And
Right.
that's the purpose of it, because like you said, it's not one size fits all. Everybody's different. Every business is different, and their liabilities will probably be different across the board as well, I would think.
Right. Right.
So, well, getting into contracts, can you explain for the audience? And a lot of people probably already know, but just from a technical standpoint, there is a lot of there's a lot of different words with these and acronyms. So the MSA and the SOW, how would you explain the difference between that and why they're so important?
So I would say that the MSA is your master service agreement.
Mhm.
And, depending on your business, you can format it with a master service agreement that contains all of the main general terms that essentially will apply to the relationship. The statement of work is usually more like 1-2 pager that essentially details the specific services that you're providing for a particular client. It really makes sense to have an MSA and SOW where you might have a scenario where maybe you're helping a client with a specific project. And so you can negotiate the master agreement once, and then should you have additional projects, you can enter into simple statements of work for those additional projects down the line without having to go back and negotiate an agreement every time. So from an efficiency standpoint, having a master service agreement with a statement of work might work. We have other clients, for example, that might just have one-off, they just work with clients on a one-off basis. Well, in that case, you really don't need the SOW and an MSA. You can just get a simple, standard service agreement in place. And then we have other clients that will have, an app or something where they create an account online where you'll just click to agree to terms as opposed to actually signing off in an agreement. All are legally enforceable, but just depending on the business, you might structure it differently for efficiency purposes. One thing I will say that I see a lot of folks doing is sending out proposals as their contracts. You definitely want to avoid that.
Okay.
Proposals, essentially you're claiming you're going to solve the client's problems and you're the greatest in the world. Well, you don't want to bind yourself contractually to that. And so it's okay to send a proposal initially to kind of help, tell a story about your services, but definitely don't use that as your binding contract.
Gotcha. That's great advice. So, so people actually take the proposal and bundle it into a contract?
They do.
Wow.
More often that they'll have the proposal, and then they'll have some additional kind of terms within the proposal, and then have their client sign off on their proposal, and they use that as their agreement. But most of the time, like I mentioned, there's like flowery language in a proposal, right? Because you want to make yourself look great to the public and say all these different types of services. You just don't want to bind yourself to that.
Well, that's great advice. I want to bring up another topic with you, something that y'all have both helped me with, your firm. when you are talking about these agreements, one of the things that I struggle with is when a vendor or someone that I'm working with, another service provider, anybody who presents me with a contract for me to sign. So I'll be on the other side of the contract. I see that a lot of contracts are one-sided. And
Yeah.
how many people would you say just read these contracts and just look through the pages and just sign and don't even read anything that they're actually signing to or agreeing to? How big of a problem is that you see?
Yeah, I mean, we see it all the time. Well, we get, especially with clients who are just starting out, they feel that they don't have negotiating power. And that's really not the case. You know, you might want to just pick your battles, but you definitely, at a minimum, I mean, what we do is we'll perform risk assessments. And for us, you know, it generally takes us an hour for every 10 pages. And so at least you know what you're getting into, you know what the risks are. And then it's really up to you as a business to decide whether or not you want to take on those risks. And so at least with a risk assessment from an attorney, you can at least understand the terms that you're getting into, what your obligations are, where you're taking on liability, and potentially push back. I mean, as Trish mentioned, you know, working with larger organizations, we know that they negotiate and we know that there's room for negotiation in every contract. And so, you know, you might not want to be super nitpicky depending on who you're working with, and you might get pushback. I mean, we get pushback from, for example, a lot of times, you know, Amazon will negotiate against, and they'll say, well, this is take it or leave it. You know, we're not changing anything, you know, type of thing. But we've pushed back where we need to push back based on various services, and they will budge, you know, depending on what it is. I mean, they may not change the small nuances where we'd want to protect, but, you know, you pick your battles and you try to limit your liability to the extent possible, and just make it very clear on what it is that you're providing and what it is that you won't be.
Well, and I'll also add to that really quick. I just think it's really important to make informed decisions. So if somebody's presenting you with a contract, know what you're getting into. You don't just want to sign it and then deal with the repercussions after the fact. At least know, you know, get the full scope of, okay, these are my risks, and okay, I'm all right taking on these risks, and I'm going to sign it as is, or, oh, gee, maybe these two things will really sink my company or really don't sit with me well. I think I'm going to push back on these things. Just having the understanding, I think, is really just a good business move overall.
And here's a simple question, but now I send off a lot of sponsor agreements and stuff, and some sponsors will sign it, and well, they all sign it, but some will sign it and then they'll just send it back. But some will sign it and say, can you send me back the signed copy? Is a contract fully signed once both parties or fully executed? I'm sorry. Is a contract fully executed once both parties sign it? Does it take both parties to sign it, or would it have any validity with just one signature?
So, I mean, I think ideally you want to put a process in place to make sure that you're getting two signatures on the document. I think if you had to argue with only one signature, you know, you could, but it's not the ideal situation. So I think, yes, you really do need to make sure that both parties are signing and have a process in place to make sure that you're storing those in an easy to find manner.
Okay. Gotcha.
And I'll just add that there's certain agreements that might be just one signature. Like if you're just getting a waiver signed, you know, there are some situations where you don't need both parties to sign, or maybe a promissory note, you know, you just need certain signatures on there to make it legally binding. So I guess there's caveats to that, but a general service agreement, if you're talking from that perspective, definitely you would want two signatures.
Okay. Well, that makes a lot of sense. So I want to bring up something that, you know, it kind of goes back to the last thing we were just talking about too. You know, I have used your company with great success to review contracts. I'm not an attorney, obviously. So anytime I get a contract, I send them over to you and say, hey, can you tell me if this is a one-sided agreement? Can you tell me, you know, what we should be concerned about here in this agreement? And I've been very pleased with the service, the price. I mean, it's worth its weight in gold. So I just wanted to say thank you for that as well.
Thank you.
So if you don't have anyone on hand that are reviewing your contracts and you're watching this, reach out to Meyer Law, and they will review them for you and let you know if it's a good agreement, if it's in your, in both parties' favor. I typically, don't like one-sided agreements. We all want contracts to protect us, but at the same time, I tend to go more for a mutually beneficial agreement, so both parties can benefit.
And I'll jump in there, Scott, and add that there's oftentimes we'll review an agreement for a client and then they realize it's super one-sided and they'll go back to the party that they're negotiating with. And that party doesn't even realize that their contract says what it says. It happens so often that then they're like, oh, well, we don't mean it to be this set out that way. That's not our intent. And then we end up changing the language, but it happens so often that folks don't even know what their own agreement says. And so just getting that risk assessment, just so you know what it means and kind of walk through. I mean, I think that's really key and important as well.
The educational part, absolutely.
Yeah.
Well, how big does a company need to be to have contracts or agreements? I mean, what about the startup companies? In our industry, I think they call them pizza techs, where or trunk slammers, where it's one person that goes out and they operate out of their car. Does that person need any kind of agreement or anything like that?
They do. They do.
Okay.
Because, I mean, otherwise you're taking on personal liability potentially. It depends, I guess, on whether or not you've set up a legal entity separate from yourself. But in either case, you want to limit any kind of exposure you have related to the services you're providing. So, I know I'm a lawyer, but yes, I think you definitely need a contract.
So it doesn't matter how big the business is, whether it's a startup, whether they just started yesterday, or they've got 50 employees. It's beneficial for everyone.
It really is.
And I think also having an agreement to give to your client makes you look more professional as well.
I agree 100%. Yeah, it makes you look like you have everything together.
So I asked you about did you take two signers, but what about an age requirement? Obviously, we probably won't have any 10-year-olds in an IT business, but is there like an age requirement for people to sign? Do you have to be a certain age to make it legally binding?
18.
18. Okay.
Mm-hmm.
Good to know.
So I guess there's a nuance to that you could enter into a legally binding agreement with somebody under the age of 18, but then that individual, because they're underage, would have certain rescission rights. And so ideally, to make sure that it's fully enforceable, you just want to make sure that they're at least of legal age of 18.
And I'll also say something else. We also include wording in a contract that says that they have the legal authority to sign the contract and it's binding and all that kind of stuff. We usually add kind of a statement in there that the signatory is making a representation and warranty to that effect.
Well, I want to ask your opinion on something, both your opinions. One of the things that I struggle with, even with having these fancy, nice contracts in place, I struggle with getting them re-signed. Any suggestions or help with that? Or when should you look at getting them, signed again? Should you do that every year?
I mean, you could take one of two approaches. You could do it as each contract kind of expires, or just say, okay, beginning of 2022, we're going to reset and we're going to roll everybody out onto these new contracts. I think thinking about the process and how to make it as easy as possible and seamless for your clients in that case is most important. So more looking at the process and procedure and how basically easy you're going to make it for them to sign on, I think is something that's really important to look at.
And then I'll also add, I think that if your agreement, if you're changing any major terms, for example, and let's assume, well, first, I think the first thing we would need to look at is how long is your agreement? Because if it expires, you're kind of forced to enter into a new agreement. But let's assume that there is auto renewal, and then you might want to look into, okay, well, am I changing my pricing structure? Am I changing any major terms? Am I adding any restrictions or requirements that I'd want to make sure that our customers, are there any new laws that have come out that I need to now protect against, So those are nuances that at that point in time, you might want to rethink your agreements. I mean, we do have some clients that want to be able to, for example, change pricing at any point in time. And so if that's the case, we can write the agreement that way where, upon a notification, if they continue on the services, you're being bound and so on and so forth. But it just depends on the structure, depends on your business and your customers. Do you bind them to a specific term? Do you not? Does it auto renew? Does it not? All of those need to be in line with how you plan on doing business.
Again, one size doesn't fit all.
Exactly.
Perfect. Well, tell us about some of the agreements and, not necessarily just contracts. What kind of agreements have y'all created, in the past for other IT businesses?
So I think it's important to look at the different relationships within a business. I think sometimes, people do think one size fits all. I can use this for this scenario or that scenario, not realizing that there are nuances depending on the relationship. So we've helped with hiring contracts, so independent contractor agreements, internship agreements, employment agreements, offer letters, NDAs, kind of those hiring foundational documents, customer agreements, as you would think, various vendor agreements, used to support the business. And then also a lot of channel partner agreements. So, to the extent you're engaging a reseller or a referral partner to work with you to get the word out about your product or service, kind of working on those types of drafts and other strategic partnerships. And then we do a lot of things specific to tech. So, software as a service, IT consulting services, software license, hardware, IoT, where there's a hardware component, a SaaS component, and a software component, so a lot of very specific agreements. And I think my advice to all businesses is to look at the relationship and to make sure that you're covering off the expectations with respect to that relationship, and then making sure that you're allowing for remedies should things go wrong. Because unfortunately, as you're entering into the relationship, everything's all positive. It always is, or you wouldn't be entering into the relationship.
Sure.
But you need a good guideline if something is not going right or doesn't turn out as expected.
Absolutely. Well, if an IT business owner doesn't typically have a contract and they want to engage your firm to help them draft up a contract, how long of a process from start to finish on average? And I know that is going to vary depending on the different businesses and their requirements, but how long should a basic contract for an attorney take, or not an attorney, for a managed service provider or IT business owner take from the time that they engage your firm to the time that you are presenting them with let's just say, the first rough draft?
I would say for us, I mean, the way that we structure things is we typically like to send a list of questions to gain the insight of how you're operating your business, to determine those nuances. Once we actually get the feedback, generally maybe a week to turn around the draft is our time process. But to the extent that somebody needs something sooner, we just ask for, let us know of your own time constraints, and then we'll work to meet it.
Great.
And I'll also say this, with IT businesses, what's really important is oftentimes IT businesses are using third-party products and services. So it's important to have a holistic look around, what products and services you're using, perhaps implementing, looking at the contracts you have in place with those third-party providers. And then depending on how your business is structured, whether you're entering into the contract with these third parties on behalf of your client or your client's entering into these relationships directly, just holistically looking at all of that and making sure that you have everything covered is really important. You don't want to be taking on liability for third-party products and services that are outside of your control. So making sure you're covered off in those agreements and then also covered off in your client agreement is really important.
So I think you're specifically talking about like possibly a supply chain attack, protecting your business.
even not even a supply chain tech, but if you're, let's say you're relying on somebody else's hardware and you're going to install that, it's on site at somebody's office, and something goes wrong with that hardware or software or a SaaS product, you don't want to be left holding the bag for that. So you need a protection in your contract with that third party provider, and then you need to be covered off in your agreement with your client, if that makes sense.
Sure. Well, and that brings up another question. Is it ever appropriate for an IT business owner when they are engaging a vendor to actually have the vendor sign a contract as well?
Yes.
Does that ever happen?
The vendor should sign a contract. Now, whether you present the vendor with your contract or they have a contract, it'll just vary. But most vendors would have contracts for their products or services unless they're really early stage. In which case, you could draft something up if they didn't have something. But yes, every relationship should have a contract, really.
Well, and I knew about the vendor contracts, but what I was really talking about was from the IT provider. Does an IT business owner ever have a contract for the vendor to sign that the vendor doesn't give the IT business owner? Do they ever come up with one? I haven't heard of that scenario before.
Yeah, we actually do. I only know because I recently drafted one for a client, but
okay.
They wanted to get all of their vendors on a standard contract to make sure that from a hardware perspective that there was minimums that, and some certain compliance standards. And this particular client also works with the government. And so they have to flow through certain governmental terms. And so they just wanted to set forth a baseline for all of their vendors to sign to make sure that they're covering themselves. And so, yeah, absolutely. It definitely does. And like Trisha mentioned, every relationship should. So on the flip side, if you're using in your business, if you're not providing all of the services and maybe you're using a contractor to provide some of the services, you should definitely have a contractor agreement as well to cover off the services that they're providing, especially if they're, meeting with your customer directly.
Right.
You don't want to necessarily also be cut out of the middle too, right? And so
That's
you need
right.
to protect yourself on both sides. You'd protect yourself in your customer agreement, and then you'd also protect yourself with your actual contractor as far as the services are being provided, who owns the relationship, what those parameters are.
Well, what is probably, in your opinion, I'm sure you've reviewed a ton of contracts. What is the biggest mistake you see IT business owners making when they present you with a contract that they want you to help them with? Or, what's a big mistake that IT business owners make with contracts?
I'd have to say the structure. They don't structure it in the most efficient manner, so it's a little bit all over the place. I think also not taking into account the exposure for third-party products and services, like I just mentioned, used to run the business. So for instance, we have some IT service providers that will provide SLAs, but they haven't looked to make sure that their hosting provider SLAs line up with what they're providing to the client. So they could be providing more to the client than they're getting from their own hosting provider. So just making sure kind of that you're looking at all of that is important.
Yeah, because they could actually be in breach of contract right out of the gate and not be able to do anything about it, but create a new contract. So, wow. So I wanted to ask you another question about non-competes and employee relationships. So a lot of IT business owners, will hire employees, and one of the things that they worry about is, if I hire this person and I train them and teach them all the trades, trade secrets and everything, and teach them to do it my method and my methodology, what about non-competes and getting the employees to sign? Are those worth their weight in gold, or what can you tell us the do's and don'ts of that?
Yeah, so non-competes are very state specific. And so, and it's usually going to be based on where the employee actually resides. So you might be, providing services in or out of Texas, but your employee is in Illinois. Well, then you'd really want to take a look at Illinois law as far as non-competes are concerned. And like I mentioned, and then there's certain states where non-competes are not going to be enforceable. If you're in California, forget about it. It's not even worth it. From your perspective, though, the way to protect yourself always is to ensure that you are covering off any confidential information. So methodologies, if you're teaching your methods to somebody, that's your confidential information. And so regardless of a non-compete, because a non-compete to me, when I really get down to when I have conversations with potential clients or clients, and we talk about what it is that they're really looking to protect, is it that they're really concerned that this person's going to go out and compete? Or is it that you want to protect your actual customer relationships? Is it that you want to protect your methodologies? And, really when it comes down to it, more often than not, I mean, there are situations where you want to prevent somebody from actually competing, but more often than not, I often see that it's really with respect to confidential informations and protections of the actual relationships, which is more of a non-solicitation than a non-compete. But non-competes, in other states are enforceable, so long as it's limited to a geographic scope, so long as it's in connection that you're trying to protect a legitimate business interest, and as long as the time frame is not extreme. Usually non-competes are 1 to 2 years. Certain states like Illinois, for example, has restrictions where if you have an employee sign a non-compete when you're first hiring, you'll need to give them additional compensation for it to be enforceable, unless that individual stays with you for a minimum of 2 years. So other states have similar restrictions. I know Illinois is changing their non-compete laws in 2022. It's constantly changing, evolving with case law as well. But usually if it's very limited in scope, they are enforceable. You can even have provisions in there where you set forth what the remedy would be automatically if there's a breach, to the extent that you can kind of estimate for that. Similar with non-solicitation. Non-solicitation would be if you're trying to prevent somebody from taking your customers or your business or interfering with your business relationships. That would be more of a non-solicitation. And that is also typically, it's more enforceable typically than non-competes.
Okay, great. Well, I've got a couple questions in the live chat. Ron Hill asked, how often should you have your agreements reviewed?
It's a good question. I would say at least once a year. And then obviously if you change your business, pivot, start providing additional services, start integrating maybe another third-party product or service, then obviously on an as-needed basis. But I think it's good to do a refresh once a year.
Okay, perfect. Stoddard Warman asked, I own a digital marketing agency and the MSA plus SOW route is great because my website work turns into advertising work more often than not, and being able to just shoot another SOW streamlines the process.
Yes.
So I don't know that that was a question. I think that was a general statement.
Yeah, we agree.
So, and Terry Uland just asked me to post a link to the event to this one to tie them both together. So Terry, I have done that. So getting back to my set of questions here, what constitutes an oral contract, and are oral contracts enforceable?
So yeah, I mean, oral contracts definitely can be enforceable, but you're just getting yourself into some, deep water if you try to go down that route, because then it becomes, an argument of whether or not you have any backup. I mean, what I tell clients all the time is if you don't have an agreement in place, then you're going to look at all of the extrinsic evidence that points to, whether or not this oral agreement ever existed. And, looking at, text messages, emails. I mean, looking back at case law, there's been enforceability with contracts written on a napkin, but that's not very ideal. So we wouldn't recommend going that route.
Well, I just was curious because my 13-year-old son, he always tries to, get me on enforcing those oral contracts, and I try to stay away from those. So, well, everybody talks about a breach of contract. In your opinion, what's the biggest way to to breach a contract?
So there's so many different ways. It could be you're not providing the services. There could be
Okay.
certain timelines that you need to meet within the contract, and maybe you don't meet those timelines. Maybe failure to pay you, for your clients to failure to pay you, or a breach of confidentiality. There could be a lot of reasons why things go wrong in a contract. I think that's why it's so important to get everything in writing and then think about what the remedy would be should things go wrong. What happens if there's a termination for breach? What happens if we breach? How do we want that handled? What happens if the other party breaches? How do we want that handled? What happens if we just want to walk away for convenience just because, for whatever reason, not that anybody did anything wrong, but just because? How are we going to handle that? Same thing with the other party. How is that going to impact us, and what would we need for that? Like, for instance, if you're using a third-party product or service within your business and you're contracting with your clients for a certain period of time, you don't want that third-party product or service provider to be able to pull that contract with you without giving you adequate time to find a replacement and then to be able to notify your clients. So just kind of making sure that you're looking at everything from that lens, I think, important.
Well, we have covered an awful lot about contracts and agreements in your IT business. Any kind of parting last words or any advice for the audience?
I would just say, if you don't know what you need, reach out to an attorney to have that conversation so that at least you can understand what you will need to get in place. I totally understand people starting out and don't have the resources, but try to budget a little bit for legal, because like Trisha mentioned in the beginning, it's just so much more costly to try to clean it up on the back end than getting it right the first time around. And it's one of those things where you don't realize it probably until you get yourself in hot water, and then you realize, oh, well, this is what the agreement was really meant to cover off. I'm hopeful that, anybody gets into that type of situation with their customers, but the whole point is to try to prevent it in the first place. And that's really what the contracts there is meant to protect and do for you.
And I'll also say that I think so often businesses don't know what they need. And so we have a tool on our website under our Founders Corner where you can request a roadmap, you answer questions about your business, and then we will either set up time to chat with you if we need more info, or we will kind of revert back with an outline of the things that you should be considering. I think, often you just don't know what you need or even where to go or where to start. And so this gives businesses kind of that starting point.
I was going to put a link to the roadmap, request a roadmap. Okay, so I'm going to put a link in the Facebook comments, and I will have that there where people can go and request it direct. Let's see here. That will be the roadmap. And all right. Anything else you'd like me to bring up or talk about?
No, I think we covered a lot. Hopefully,
we did.
It was a crash course. If you have any questions, obviously circle back with us, and we're happy to kind of talk further.
And what is the best way if an IT business owner wants to engage your firm? What's the best way to do that? Get started?
Probably the easiest email address to remember would be info@meetmeyerlaw.com.
Sounds great. Well, I really appreciate y'all taking the time to meet with me today and go over the contracts, all things contracts and legal agreements. So it's been fun. Thank you so much.
Thanks for having us.
No problem. We'll have to do it again.
Yeah.
All righty.
Thanks.
Have a good day.
Y'all have a great day. Bye.
Bye-bye.